From the opinion pages of the Wall Street Journal, this is Potomac Watch.
A federal appeals court blocks parts of Florida's law regulating social media websites as Elon Musk's takeover of Twitter falls into question. Welcome, I'm Kyle Peterson with the Wall Street Journal. We're joined today by my colleagues, editorial board member Alicia Finley and editorial writer Mene Ukwe-Barua. Welcome to you both. Last year, Florida and Texas both passed laws trying to regulate how or for what reasons a social media site may remove posts or ban users. And we're now getting the first court rulings on whether those laws meet constitutional scrutiny. But let's start with the governors who signed those bills. First, here's Texas Governor Greg Abbott last year, followed by Florida Governor Ron DeSantis responding to a question from a reporter.
There is a dangerous movement by some social media companies to silence conservative ideas and values. This is wrong, and we will not allow it in Texas. Today, I'm about to sign a law that fights back against big tech political censorship. It prevents social media companies from banning users based upon the user's political viewpoints. It allows Texans who are wrongfully deplatformed or restricted to be able to file a lawsuit to get back onto that social media site.
You're a loyal supporter of former President Donald Trump. Donald Trump is now a resident in Florida, and he was deplatformed. Is this bill for him?
The bill is for everyday Floridians. This is what we said, and it will allow any Floridian to be able to provide what they're doing. So, but I do think that's another issue that has been brought to bear. When you deplatform the President of the United States, but you let Ayatollah Khomeini talk about killing Jews, that is wrong.
So the most recent ruling on this came out last week on Monday from the 11th Circuit U.S. Court of Appeals, which struck down some but not all of this Florida law. Alicia, why don't you take us through the court's ruling?
Short and simple, it ruled that the law violated the First Amendment rights, the speech rights of these platforms. Now, circle back, what does this law do? So it's a multi-fanged law that would require platforms with at least 100 million monthly users globally and 100 million in gross revenue. So this would cover Facebook, Google, YouTube, Twitter, basically all the big social media platforms, and potentially, to be honest, some others, Netflix too, even though that's not really considered a social media platform. So the law would require these platforms to publish their standards for how they police content, apply moderation consistently among users, and give the users whose content was removed a thorough rationale. A lot of this is just due process, that if you're going to take someone down or take someone's post off your platform, you have to explain to the user why. But it goes a little further and also forbids platforms from willfully deplatforming or shadow banning, which is essentially limiting the exposure in news feeds of candidates for public office or the content about them. They also can't censor quote-unquote journalistic enterprises with revenue of more than 100 million and 50,000 paid subscribers. So this wouldn't cover just the average blogger, but would cover most big news outlets, including it was really seemed to be aimed when Twitter took down the New York Post story about Hunter Biden's laptop. Now, the question is, does this violate the free speech rights of these platforms? The platforms argue it does, that they are editing, that they have the right to edit this content, and that therefore any kind of restrictions on their ability to take users down or posts down violates their First Amendment rights. Now, the Fifth Circuit, by and large, agreed with them, and I'll just take a quote the judges said, or not the Fifth Circuit, sorry, that was the 11th Circuit, agreed, saying, taking stock, we conclude that social media platforms' content moderation activities, that is, permitting, removing, prioritizing, and deprioritizing users and posts, constitute, quote-unquote, speech within the meaning of the First Amendment. All but one of the law's operative provisions implicate platforms' First Amendment rights and are therefore subject to the First Amendment scrutiny. And the way that they applied this First Amendment scrutiny, the judges decided it violated their First Amendment rights.
So I'll just underline a couple things there. First, this is the judge writing for the 11th Circuit is Judge Kevin Newsom. He is a Trump appointee, and he says these are private platforms, and they are also protected by the First Amendment. They have editorial judgment. The other case, Mene, that's circulating is in the Fifth Circuit Court of Appeals, And initially, the district court judge there, Robert Pittman, blocked the Texas social media law. Then the Fifth Circuit stayed that ruling, and now the tech firms, I believe, are appealing to the Supreme Court. So maybe, Monet, the place to start there is, why don't you give us a sense of what Judge Pittman said?
So what Judge Pittman said, and this again is the district court judge who ordered the injunction on the law in December, was essentially the same as what the 11th Circuit Court of Appeals just said in Alicia's summary. So to back up even further, Texas passed this law, which is somewhat different from the Florida law, but was also intended to restrict the censorship ability of tech platforms last year. This was reviewed by a federal judge in December, Judge Pittman, who said that the law was infringing upon the free speech rights of these tech platforms, including Facebook and Twitter. Basically, he said that the Texas law would have the effect of treating these companies sort of as if they were restricted entities, violating their freedom to make editorial decisions about what content they publish. This month, we had a lawsuit from Ken Paxton, the Attorney General of Texas, which resulted in a panel of the Fifth Circuit Court of Appeals deciding to stay that injunction. So now the law is going to be allowed to take effect. The curious thing about the Fifth Circuit decision is that we don't know exactly what their rationale was in ordering the injunction to be lifted. It was issued per curiam, so it was a split decision among 3 judges, but we don't know who voted in what way, and more importantly, there wasn't actually an attached description of why they decided to reverse that district judge. But if we look to the hearing, which took place shortly before the Fifth Circuit Court of Appeals decision, we can see one of the issues they were discussing was whether these platforms are more like common carriers or whether they're more like publishers. And so basically the judges were asking, maybe actually Facebook and Twitter are more like the phone company. Maybe because they have such a big reach on allowing people to disseminate their views online, the law should treat them more like a neutral provider which doesn't have the ability to block users and less like a sort of individual platform. And so we won't know for a little while exactly why the Fifth Circuit decided to uphold the Texas law, but it does seem likely that they are opening up that question about whether these platforms are so big and have such a central role in free speech today that they shouldn't be able to censor political speech.
Well, and it's important also to note that these are big laws with lots of things in them. And so the courts are also treating different provisions differently. So just to go back to the Florida law, a couple of the provisions that the 11th Circuit said were constitutional in its view, one of them, and this is the court summary, says that a social media platform must publish the standards, including detailed definitions it uses or has used for determining how to censor, deplatform, and shadow ban. That is constitutional according to this 11th Circuit ruling. Another one is under the heading of data access. The social media platform must allow a deplatformed user to access or retrieve all of the user's information, content, material, and data for at least 60 days after the user receives notice of deplatforming. And those, to my eye, look a little bit like business regulation of the service that these social media companies are providing. And I would distinguish that, I guess, from the rules in these laws that look to me more speech-based. So the Texas law says a social media platform may not censor a user's expression, or a user's ability to receive the expression of another person based on the viewpoint represented in the user's expression. And the Florida law has something similar for candidates. It basically says that if you're a candidate for any office, you are not allowed to be deplatformed or censored on any of these platforms. And Alicia, the hypothetical I'm wondering is if this law, the Florida one on candidates, goes into effect, then isn't everybody who is banned from Facebook or Twitter for harassing people or for expressing really odious views, Nazism to pick one, why aren't all those people going to go out and decide they're going to run for the local sewer commission? And then poof, they're immune from anything that these social websites want to do to stifle what they're expressing.
Well, I think that there's the parade of horribles that the tech companies have been kind of using to scare people that all of a sudden their platforms are going to become cesspools of neo-Nazism and such. I don't think that's going to happen. And I think the problem with the tech platforms arguments is they want to be treated on one hand like a mere distributor of information for the purposes of Section 230, which is a federal law that restricts liability for content platforms that is not their own content. So they want to say that on one hand, this isn't our content, we're not endorsing it, we're just a mere distributor. On the other hand, they want to claim for the First Amendment purposes that they are actually speakers of this content, editors, just like publishers. And you can't have it both ways. And I think that's where the potential Supreme Court challenge would go. And I think that there is some interest in the justices in taking up this issue, judging from Clarence Thomas's opinions in the past.
Well, I guess I disagree with that. I don't know that there's any contradiction in their position here. And all analogies to this new technology are imperfect, but I think of it like a public billboard. If you own a coffee shop or something like that, you could have a public billboard. And the general policy could be that anybody can come in and put up a poster for something they're selling, an event they're holding, and yet the owner of the public billboard can still have the right to go through, and whether he does it every day, takes a glance at what's up there, whether he waits until people complain about something that's up there that really shouldn't be, he has the perfect right to go through and take things down. And that's an argument that the 11th Circuit is pretty explicitly making, that these sites are not dumb tubes. The 11th Circuit opinion takes one example. It says there's a vegan forum, allows non-vegans, but will not tolerate members who promote contrary agendas. And the implication is that that's no different than Instagram's decision to ban nudity or Twitter's decision to ban Donald Trump. And to the point about whether they're, dumb tubes, common carriers, there's a lot of talk lately about one of TikTok's advantages is that it doesn't give you just a reverse chronological series of posts. There's some algorithm that is very good at picking up what users want. And so why can't part of that algorithm, Monet, be that they discount things that are not widely liked by the user base of the social media site? I mean, don't forget, these are businesses. They're quasi-media companies making money off of advertising.
I think you make a good case there for treating these platforms as if they are sort of independent actors whose editorial decisions should be protected by the First Amendment. And that's what we saw the 11th Circuit judges saying, and that's again what we saw that district judge in Texas saying about these laws. So I think on the one hand, you have a lot of conservatives who are deeply upset with what is obviously bias on behalf of these very large and influential platforms against conservative voices. And they're all just trying to figure out, is there any way within the scope of the First Amendment that we can create provisions that would be able to sort of restrain that bias? But they're coming up against some of the difficulties in the law. And again, I think the case that you just laid out is persuasive in some ways. I think it's interesting to look at how the Texas law was structured in that vein. Like I said, it was a little different from the Florida law. And the main difference was that they sought to create a private right of action for individuals to open up lawsuits if they believed they had been discriminated against by these tech platforms. So instead of just outright banning bias and saying that platforms aren't allowed to remove political candidates for speech that they don't like, the Texas law basically said if you are a political candidate, you've posted something on Facebook, the company still has the ability to remove you, but if you believe that that removal was motivated by unfair political bias, then you can potentially bring a lawsuit. And I think the importance of this distinction is that a judge would still be making the determination, did Facebook have the First Amendment right to remove your speech? Or was there potentially some unfair bias that they exercised in making that determination? So that the law itself does not sort of create a standard that could run up against the First Amendment. It basically delegates that judgment to a subsequent judge to decide. So it could ultimately come up against the same exact problem. Maybe Facebook has an unlimited ability to remove speech that it believes it doesn't want to have on its platform. But at the very least, the letter of the Texas law seems a little bit better tailored to stand up against First Amendment scrutiny. But again, these are really complicated questions. Conservatives all see the problem of the power that these platforms have, and they're going to sort of keep trying different legal strategies to see if they can come up with something that passes muster.
Hang tight, we'll be right back. You're listening to Potomac Watch from the Wall Street Journal.
From the opinion pages of the Wall Street Journal, this is Potomac Watch.
Welcome back. Before the break, I was responding, Alicia, to you a little bit, and so now I'll give you the chance to respond to me. And I guess I would point back at the Texas law that says that social media platforms can't censor user expression based on viewpoint. And the question I keep coming back to without an answer is, what is a viewpoint? I mean, does that mean that Facebook is legally required to host on its servers and to disseminate to users any event invitation for a neo-Nazi rally that anybody in Texas wants to put up? And I get that there's a parade of horribles that these social media sites are putting out there, but if you go spend a little bit of time on other social media sites that are not moderated, there's a lot of stuff there that I think is not friendly to, at the very least, the business decisions of Facebook and Twitter. It's not the kind of places that they want to be.
Well, I think to Monet's point, some of these determinations under the laws would be made by judges. What exactly does deserve First Amendment protection and what doesn't? I think what's also important is to know, at least on the Supreme Court, its precedents would seem to favor or allowing these kind of regulations. If you go back to the Pruneyard case in 1980, that was when the U.S. Supreme Court upheld a requirement that basically a shopping mall allow all kinds of speech. Now, the Supreme Court has gotten much more protective of the speech rights of businesses since then, so maybe you can imagine that they could overrule Pruneyard, but that is the current precedent of the Supreme Court. I'd also go back to, Clarence Thomas and his concurrence in an opinion, seemingly suggesting that someone tee up a case so that the Supreme Court could actually review these kind of tricky issues. And he said, quote unquote, internet platforms, of course, have their own First Amendment interests, but regulations that might affect speech are valid if they would have been permissible at the time of the founding. Federal law dictates that companies cannot be, quote unquote, treated as the publisher or speaker of information that they merely distribute. So there you have him suggesting that they do not enjoy the same protections as a newspaper. And he goes on to say that the long history in this country and in England of restricting the exclusion rights of common carriers and places of public accommodation may save similar regulations today from triggering heightened scrutiny, especially where a restriction would not prohibit the company from speaking or force the company to endorse the speech, which is essentially the case in both the Texas and Florida laws. Again, these both laws are very complicated. They have many components, but I don't think it's a clear-cut case that they automatically violate the First Amendment.
Meanwhile, the news that was supposed to shake up the social media landscape seems now to be in a little bit more doubt. Elon Musk had been planning to buy Twitter. He put in a bid that was accepted. And then last week, he is muddying the waters a little bit, saying that as many as 20% of the accounts on Twitter might be fake spam accounts in his view. Here's the Elon Musk tweet: 20% fake spam accounts, while 4 times what Twitter claims could be much higher. My offer was based on Twitter's SEC filings being accurate. Yesterday, Twitter's CEO publicly refused to show proof of less than 5%. This deal cannot move forward until he does, unquote. So, Monet, what is your read of what's going on here and the likelihood now that Elon Musk is trying to back out of it, or whether he's able to do that?
Well, I think that his decision-making here probably has more to do with the general direction of the stock market than it does with the specific question of how many fake accounts Twitter has. And I'll back up and say that when it first came out that Elon Musk had acquired a significant stake in Twitter, sort of my reading was that he probably was doing that as much for the prospect of financial gain as for sort of the altruistic explanation that he gave about wanting to reform Twitter. And I think that, we've seen Elon Musk's sort of presence as a figure and his ability to move the markets. He's done it with Tesla in terms of every time he speaks, he's able to sort of boost the value of that stock. We've seen it with cryptocurrencies, specifically Dogecoin, if people can remember back that far. When Elon Musk acquired a stake there, he was able to increase its value tremendously. So he knows that him as a public figure is able to lift the value of any equity that he holds. Knew that the same thing would happen with Twitter, and we saw exactly that happen. Since that time, obviously, Twitter's value has declined along with the rest of the stock market, and so the value of his acquisition is not looking quite as good as it did a month or so ago when he was first getting involved there. And so he might be looking to back out, or he might just be looking to change the terms of the purchase, but he definitely is flagging this question of these bot accounts partially with an eye toward what is the value I'm going to get out of Twitter. Now, all of that said, he's right to flag the problem, and he isn't the first person to do it. A lot of people have pointed out that a big share of Twitter's accounts are fake, that their rate of growth has lagged compared with some of the other social media sites, and that's something that's very important for the amount of advertising revenue that they're able to gain. So whether he's doing it mostly for cynical and self-interested reasons or mostly because he actually has sort of a real concerns with how Twitter represents how many of its accounts are fake, he's exactly right to scrutinize that issue, and we'll see whether Twitter is able to turn up a satisfactory answer about sort of the proportion of their accounts that are fake and what they're doing about it.
Alicia, do you agree that that's the best explanation for Musk's behavior here is the fall in the stock market, including probably his Tesla stock? And what's the likely outcome here? Because Twitter says it's going to try to enforce the merger deal, and is Elon Musk maybe going to end up paying that breakup fee?
So I would agree that this is generally a pretense for trying to renegotiate the deal beyond just the falling stock price. And as you mentioned, the Tesla's falling stock price, which means he would have to put up more of his Tesla as collateral for his margin loan. Interest rates are also increasing, which part of the deal would have been financed by leveraged loans, which the interest rates vary with general interest rates. So those would have gone up. The issue is that this Twitter would not have had the cash flow to make the payments on its debt. So you're seeing is trying to change the financing of the deal. He's, trying to bring in other potential shareholders and increase the equity stake, not his own equity necessarily, but others, bring in other investors. And I think it's going to depend on if he can make the financing work. If not, he may have to pay the breakup fee, because I don't see him going ahead with a deal where he feels like he could lose money on it.
Thank you, Alicia and Monet. Thank you all for listening. You can email us at pwpodcast@wsj.com. If you like the show, please hit that subscribe button on your favorite podcast app, and we'll be back tomorrow with another edition of Potomac Watch.